right. Welcome back to the Scaling Laws Academy. We've got another exciting class up today. We're exploring the dynamic area of AI and the law that you perhaps are overlooking, and that is, of course, torts. And I'm so glad to have Gabe joining me today. As always, we'll be using our standard format here. First, we're going to explore the fundamentals of the law. Yes, we're going to go back to torts, that 1L class you either loved or hated, or the thing that you've heard of when you talk about the law. Next, we'll go into how torts and different theories of liability intersect with AI as it stands right now, before concluding with some discussion over how liability may be impacting the direction of AI development and where we may see that direction go in the near future. So, with all that, Gabe, easy question. Why do we have torts?
Right. So sometimes people hurt one another in various ways. Those could be bodily injuries. They could be damage to property. And under some circumstances, they have to compensate the person they harm. And so tort law is the body of law for when you have to do that. So if one person's suing another, it's not because they made a promise that they're not keeping. That's contract law. It's not about who owns some piece of land. That's property law. All other lawsuits where it's one person suing another are going to be tort suits.
Okay, so let's start here because this is excellent. What about contracts? Why can't contracts just cover everything? Couldn't I just write a contract with everyone about the preferred way they'll treat me and address me?
Yeah, so there's an idea in economics called transaction cost to write, there's something like 7-8 billion people in the world. To try to write a contract with all of them would be pretty difficult. You'd have to get them to agree. And some people just don't really want to engage with other people, right? And so, and also say someone's doing something you have to bargain in the context of some default set of rules, right? So if right now the default is people get to build, say, AI, right? And if it harms me, then I don't get compensated. They have no reason to bargain with me, right? Conversely, if I do have a right to say stop them, then they would have to bargain with me to get to do whatever they want to do, right? But we need some clear background rules in order to have an environment to contract in.
So contract law doesn't solve everything. All right, excellent. What about just having regulations for everything? Why can't I just have the government say, hey, no one gets to punch me? I mean, in fact, we already have that. Or nobody can assault me or batter me. So if we have these criminal regulations barring certain conduct, why do you need a civil alternative?
Okay, so first of all, I would sort of flip that around, and I think criminal law comes in when tort law breaks down, right? Because tort law is inherently more efficient, right? So if you stab me and they put you in jail, right, that costs the government money. It's bad for you, right? It doesn't actually help me at all, right? So the punishment that you get is full of what economists call deadweight loss, right? And so we might have to resort to that in sort of extreme situations where we don't have any better legal tools. But it would be better if we could give you a disincentive to do something that hurts me in a way that produces as least social loss as possible. So if instead you have to compensate me for the harm you did to me, well, that's just a transfer, right? It gives you an incentive not to harm me in the first place, but it's much less costly from a social perspective than imposing some sort of a criminal punishment like imprisonment. The other big reason is just there's a lot of information problems related to sort of writing down prescriptive rules, whether they're criminal laws or administrative regulations. And tort law can sort of step in and fill the gaps when it's hard to sort of write down in advance what procedures you would need to follow in order to solve some social problem.
All right, so we can see torts fill a sort of regulatory void in many ways where contract law perhaps isn't solving it. Perhaps we don't want to criminalize it, or perhaps we just haven't criminalized it yet and we'll get there down the road. We're also keeping me out of jail, which is excellent. My wife thanks you. So we've got the basic reason for torts. Now, I think a lot of law school students or law grads listening, or folks just watching way too much SVU or Law and Order, are going to say, okay, well, I know torts. We've got battery, we've got assault, we've got the biggies. Those are the intentional torts. And for the sake of this class, we're just going to ignore those entirely because I don't, or tell me if we should. Do you want to explore the
So I
merits?
don't think human intentional torts, except in maybe the misuse context, right, where someone's intentionally using an AI system to say create a bioweapon or launch phishing attacks or those would be intentional torts. I think the other context in which you could imagine the law of intentional torts being relevant is if we think of the AI systems as being entities with duties, they might commit intentional torts. And then there's a question, first of all, of like whether we want to try to have a liability regime for the AIs, but also whether humans that created them would be vicariously liable for their intentional torts. And so there's a number of ways intentional tort law could be relevant.
Okay, so we could see intentional tort law in some edge cases, and perhaps we'll save that for an extra credit class, but we have plenty to dive into on the unintentional tort. So let's stick with this just basic idea of negligence. What's the need for negligence? What's it solving for? And what are those key elements?
Right. So there's lots of things that people do that can create risks of harming other people, right? And we need some principle. So it's not that you're trying to harm anyone, right? That's not your goal. But it might be an unintended consequence of your action. So if you're speeding, you're driving 120 miles an hour on the freeway, you're much more likely to get into a collision that would cause some other road user to be hurt, right? And we want to have some social rule as to when you're going to be responsible for the consequences of those decisions. And so the basic sort of normative principle underlying negligence law is that we all have what's called a duty of reasonable care. So I have to behave with respect to risks to you roughly as I would with respect to risk to myself, right? So if it wouldn't, so when I'm like walking down the street, I, maybe I'm to run at the last minute to catch a signal, right? And I'm gonna calculate, well, how much time am I gonna save by making this? What's the risk that I get run over if the light changes, right? I'm gonna do some sort of risk utility calculation, right? This reasonable care principle says I should do that for risks of harm to you, not just to me.
Excellent. So we have this general notion of owing one another some amount of reasonable care. That's our duty to one another. Mm-hmm. So we've got one element down. We've got three to go. So this theory of negligence, protecting ourselves from the more erroneous or extreme behaviors of others. What constitutes a breach, and what other elements should we be thinking of here?
Right. Okay. So we've got the duty. Breach is just have you fulfilled your duty, right? So that's pretty simple. Breach and duty are pretty entangled with one another. And then, well, you need to actually have suffered some injury, right? And so in a negligence case, the element is called actual harm. Actual harm means a physical injury. It need not be a bodily injury. It can be a tangible injury to property, but typically purely financial losses are not covered and emotional harm is not covered. There's a separate tort of negligent infliction of emotional distress that covers purely emotional harms, but there's additional elements you have to meet in that context.
Okay, and then of course we have causation. So what are two considerations there?
Right. So there's two kinds of causation. There's what's called factual cause and proximate cause. Factual cause is probably what most people think of when they think of causation. And this is typically formulated in terms of what's called but-for causation. And so but for my conduct, but actually but for my breach. Had I fulfilled my duty of care, would that have prevented your injury? And if the answer to that question is no, then we can't say that my breach caused your injury, because it would have happened anyway, right? And you have to prove all these elements by the preponderance of the evidence, which means, just over 50%. And so really what you have to prove is more likely than not, had I fulfilled my duty of care, your injury would have been prevented. There's some nuance to that in terms of edge cases where the but-for test breaks down, but that's the basic gist of it.
Okay, so we've officially covered everyone's 1L tort year in approximately 9 minutes. Excellent.
Well, we didn't get to proximate cause.
I'm there. Oh, yes, proximate cause. See,
yeah.
What a bonus.
Okay, so proximate cause is this idea that it's or sometimes called scope of liability. It's the sort of risk, the injury arose from the sort of risk you should have been worried about that made your conduct unreasonable. So that might be a little hard to follow. I'm going to give you an example where it would clearly violate proximate cause, and I think everyone's intuitions would be liability would be inappropriate here, right? So say we're both driving on the road, and I cut you off in traffic, and you have to slam on your brakes, but we don't collide, right? But you're slowed down by say 5-10 seconds, and then a mile down the road, you're sideswiped in an intersection, right? That you would have cleared before the other car got there. And you want to sue me saying, well, you were negligent, right? And your negligence caused my injury. So you breached your duty of care to me. But for your breach, this injury would have happened. No court is ever going to hold me liable for this, right? Because it wasn't a foreseeable consequence of my breach. That wasn't what made it unreasonable to cut you off. In fact, it's just as plausible that I could have prevented that later injury. Maybe the car was coming 10 seconds later, or 10 seconds earlier, and I made it so that you weren't there in time, right? And so, yeah, the basic idea is it's got to be the sort of thing that made my conduct unreasonable. The sort of risk is what caused your injury.
Perfect. And so I think everyone, as you pointed out, can kind of intuit, well, obviously, I mean, there's just so many intervening events between your slamming on the brakes and then a mile down the road, I happen to have this accident. So taking these principles of negligence and these elements of negligence, before we get into some other torts, let's just think about this in the AI context right now. So
Sure.
Folks throw around, all right, well, we need tort for AI. There's already probably dozens of articles out there on this specific question of negligence. I know our good friend Chinni Sharma has written about the duty of care that engineers may owe as a result of developing these models. Other folks have talked about the sort of expectations placed on developers of the models, of deployers on the models. Can you explain how we might see negligence be applied in the AI context and what folks are throwing out there?
Right. So I think I have a slightly different view from some other people who have written about this, but I'll try to present it as neutrally as possible to start off with. But in general, what the duty of care requires, we talked about reasonable care. The basic idea, or one formalization of it, is you have to take all precautions that would pass some cost-benefit test, right? And so one question that often rises is what the scope of that is, right? So if overall, building an AI system creates more risk than its benefit society, is that what we mean by negligence? Or is it, well, was there some specific measure that passed a cost or risk utility test that would have prevented your injury? Courts tend to do a more narrowly scoped breach analysis. So again, I'll come back to a driving example, right? Say you're a pedestrian and I accidentally run you over with my car. A court's typically not going to ask a question like, well, was this car trip, this incremental car trip, worth? Did it provide enough value to me, enough net private value to justify the risks to pedestrians and other road users? Or say I was driving an SUV, was the incremental value over driving a compact sedan worth the extra risk that a heavier vehicle imposed on other road users? Those tend to be outside the scope of the negligence inquiry. Instead, a court's going to ask questions like, well, was I drunk? Was I texting? Was I speeding? Stuff like that. And so I think in the AI context, we're likely to see a similar phenomenon where the question isn't, well, was it reasonable to develop and deploy an AI system with these broad sort of structural features given the current state of AI alignment and safety science? Instead, I think it's more likely to be, well, was there some clearly established best practice that would have prevented this injury? A reasonable person would have implemented it. You failed to. I think that's more what the analysis is likely to look like. So if you have clearly inadequate cybersecurity and someone hacks into your system, steals your model weights and uses it to do something bad, there's maybe some proximate cause issues there, but I think there's pretty clearly a breach. If you're just like not using ROHF or something like that, or you're not doing very basic red teaming, I think that's going to probably be negligence. But I think it's going to be hard for the range of activities that most of the leading labs are engaged in to make a negligence case.
Well, and to just zero in on this for a second, because I think there are a lot of folks who would love for there to be clearly defined and obvious negligence case studies that we could point to and say, yes, here's how negligence will play a role in AI governance. But to your point on the question of just what duty you actually owe, not to go all the way back to Learned Hand and various cases about boats and customs, but torts usually are the product of a lot of societal norms building up about what we expect, what we want to see. So, as you pointed out, in a cybersecurity context, it's easy to say, hey, yeah, you need to implement two-factor authentication. Those are table stakes, everyone gets it. When it comes to, oh, hey, you needed to do this specific sort of red teaming before you release this model, I mean, I could probably find different articles on Archive right now that say, oh, no, that's a great red teaming exercise and that one's horrible, or vice versa. Does that, for you, is that a barrier to some of the reliance on a negligence scheme for governance in this context?
Yeah, so I think it's a combination of it's not clear what reasonable care means in this context. There's a lot of disagreement about the best way to build these systems, what practices really are warranted, and I think it's just in some sense my bigger concern is about the scope of the inquiry by default. So I think similarly in the AI context, the question is not going to be, well, was it reasonable to deploy or to develop and deploy a system with certain broad parameters, given the current state of AI alignment and safety science? Instead, it's going to be, was there some specific precautionary measure that you could have taken? And I think that's likely to be inadequate because AI alignment and safety involve unsolved technical problems. They're going to require, big investments in coming up with the strategies that no one's thought of yet. They're going to make these systems safe, and sometimes it might mean going slower. And famously, negligence law is bad at controlling what's called level of activity. Right. So, I was talking about driving, it might, negligence law might encourage me to not drink when I drive, to follow the speed limit. It's not going to make me drive the optimal number of miles that account for the risk that it creates other people. And so I think in the AI context, it might not restrain racing forward to build systems that are profitable, but might create a lot of social risks.
And so we've kind of crossed off, well, breach is going to be a tough one. Causation in particular for negligence in the AI space. We've heard a lot about this so-called black box issue and the opacity of how these systems are even working. So that seems to me like it may present one causation issue of just saying, hey, we're not exactly sure how this model actually resulted in this, or we're not sure exactly how this model generated that outcome. We're not sure entirely how it works. So whether it's the but for or proximate cause gets a little complicated of saying, if you had implemented even this known safety precaution, we don't know for certain how the model would respond. Is that the right way of kind of thinking?
Yeah, I think particularly this nexus between breach and causation, you have to show that more likely than not, if you had done X reasonable thing, it would have prevented this injury. I expect that to be hard to do. I don't think it's never going to be the case that you can bring successful negligence cases. The way I like to frame it is that even if, there's liability in all the cases where there is sort of a provable link between breach and the injury, that's not going to incentivize an adequate degree of caution from a social utility perspective.
And then finally, just to cross off all of our T's here, on the harm aspect, I think there's a desire among some to make tort law an answer for even the economic harms. But as you noted, there's this pure economic loss rule. How does that really cabin the applicability of negligence in the context of AI? Because we're not seeing right now, we don't have the sort of humanoid AI that's going to punch me in the face. So we already crossed off the sort of physical harm that we usually associate with torts. What would it even look like for the models we have right now for a non-economic harm to result that would be actionable under negligence?
So, you can imagine, the most obvious example is like an AV gets involved in a crash, an autonomous vehicle gets involved in a crash and someone's hurt, right? Now, what exactly the standard of care is there? The AV itself, at least by default, is not a person is not a legal person, right? So it doesn't have duties of reasonable care. The people who built it do, but tracing, causation, and you have to show that they failed to exercise reasonable care, and that failure what was the reason, or had they exercised reasonable care, it would have prevented the person's injury down the line. I think that's going to be difficult. In that context, products liability, which maybe we're going to talk about, is also potentially available. So maybe it's worth getting into that now.
Exactly. Thanks for making my transitions all the more seamless. So we've crossed off negligence. Let's go into the world of products liability and see if there's recourse there for some of the alleged harms from AI. So historically, as we noted, there was just this sort of notion that, hey, your only recourse against a manufacturer of a product was contingent upon there being a contract. Then we get our famous case, McPherson versus Buick, and suddenly the citadel of privity comes crumbling down, and we no longer have to rely exclusively on contracts for a sort of remedy against a defective or faulty product. So, what is products liability, and why might it be kind of useful for even a novel technology that has the sort of uncertainty that we flagged earlier that made it less amenable to negligence?
Right. So the basic principle of products liability is if you buy a product from a commercial seller, and we can talk about what both of those terms mean, product and commercial seller, because they are important gates on the applicability of this regime. Let's assume for the moment that you're in the products liability world, then if a product has a defect, and that defect is the cause of your injury, same causation standards as in the negligence context, then you can sue anyone in that sort of distribution chain. So you can sue the designer, you can just sue the manufacturer, you can sue the Amazon. If you bought it on Amazon, you can sue the seller, right? Regardless of whether you can prove that they failed to exercise reasonable care. This is often called strict liability because you don't have to prove sort of anyone failed to exercise reasonable care. I think that overstates it for most kinds of defects. So there's three kinds of product defects. There's design defects, there's warning defects, and there's manufacturing defects. The test for manufacturing defects comes the closest to what I would call genuine strict liability. So if an individual unit of a product comes off the assembly line, deviating from its specifications in some way that makes it unsafe, and you're injured as a result of that, it doesn't matter how much they invested. It can be, 999,999 out of a million come off the line safe. One doesn't. They've made lots of reasonable investments in quality control. Still, the 1 in a million that injures someone, the manufacturer is liable for that.
And just to stick while we're on manufacturing defect, could we even think of a manufacturing defect with respect to an AI? What would that look like? Because you've got one model, right, that's operating, and what would a defect even mean in this case?
So a defect would be something like you ship an instance of the model where there was a transcription error with the weights and you get like a slightly corrupted version of the model. I don't think this is a major source of AI risk, which is what you're suggesting. So even though there is this thing that's pretty close to what I would call genuinely strict liability in the manufacturing defect context, I think it's not really relevant to AI. I think these probably aren't going to happen. It's pretty easy to make perfect copies of software. And if they did, it's just like not the major source of worry.
Well, let's move on from it then. So we've covered manufacturing defects. Our other two.
Yeah. So the other two are design and warning defects. I think design defects are the most relevant. And there the question is, was there some reasonable alternative design that would have prevented this injury? And the reasonableness of an alternative design is assessed in terms of, well, how much safety risk could have been prevented? How much would that have sacrificed in terms of, cost or, performance, other product features? And so that analysis looks pretty negligence-like in practice. It's still strict liability in the sense that you're assessing the design itself. You don't have to prove that any human along the way behaved negligently in the design process, as long as the design itself was unreasonably unsafe. And so it's not exactly like a negligence inquiry, but I don't think it's as strict as sort of the label sometimes suggests.
And there again, it seems to me like we'd run into the same sort of questions we were talking about in negligence, where we don't know what definitively a reasonable model is versus an perhaps unreasonable alternative, or vice versa, right? Thinking about well, you should have released this version of Gemini, but you released that version instead.
Mm-hmm.
Now we're going to come after you under products liability. Is that a limitation here?
Yeah, so I think both negligence and products liability are pretty good for bringing sort of like 10th percentile bad actors up to something close to the median. I don't think they're good at sort of pushing forward the frontier, right? And so if you think AI safety involves these unsolved technical problems, as I do, and you think that we need even the sort of best performing labs to do better, then I think both negligence and products liability are going to fall short in that regard.
And just for sake of completion, I think we left out warning defect. So what would a warning defect look
Right.
like?
So warning defect is if there's some sort of piece of information that a reasonable person would have disclosed that's relevant to the safety of the product, and your injury is caused by that non-disclosure. Assuming there's this what's called heeding presumption that assumes you would have read the warning and paid attention to it. I don't expect these to be super relevant in the AI context. I expect there to be lots of disclosures in the terms of service. And so, it might come up, but I think, you can get them to disclose everything in the world, and it's not going to ultimately protect against a lot of these risks.
So we're racing through tort law here. We've crossed off negligence. We've crossed off products liability. Where do you want to go next?
Right. So there's other theories of what I would call genuinely strict liability that I think are relevant here. So one is called the abnormally dangerous activities theory. So if you're blasting with dynamite, or there's a related doctrine related to keeping wild animals. So if you keep a pet tiger and someone's injured in a way that arises from that inherently dangerous nature. So someone's hit with a piece of rubble from the dynamite blast, or someone's bit by your pet tiger, then you're liable for that harm, regardless of whether you exercise reasonable care. And so these are activities that are both uncommon and still pretty dangerous, even when you do exercise reasonable care. And the idea is you should sort of bear the risk that you're creating by engaging in this activity. I think plausibly courts, if they sort of were convinced of the sort of factual case around AI risk, could apply this doctrine. So I don't think it would require a substantial doctrinal innovation. It would just be extending this existing doctrine to cover frontier AI development, saying that that's an abnormally dangerous activity.
Yeah. So to drill down on those two components you mentioned, first, the uncommon aspect, right? So what makes it uncommon to have a tiger is that very few people have a tiger, right? And in an AI context with these frontier models, how might that get complicated if we see, for example, more instances of things like DeepSeek, where suddenly everyone is capable of producing new models that are near or just short of the frontier? Does that suddenly chip away at that uncommon element? If we hand everyone a stick of dynamite, just for sake of the analogy, is it no longer abnormally dangerous? It's just dangerous and everyone has it?
So I think even with a generous interpretation of what counts as a frontier model, there's maybe 10 companies in the world that are building them. DeepSeek, what DeepSeek did with R1 was impressive, but it wasn't something anyone can do. They were still using, millions, if not billions of dollars worth of compute to train this model. It was still a very expensive proposition. It's true that they were doing it under this export control regime where China doesn't have access to as much compute as the leading US labs. But it's not something anyone can do in their basement.
Not yet.
Right. If we get to that world where you can train a very powerful model on your laptop, right, then I think it would be hard to say that it's an activity not in common use. I think that's right.
Okay. Fair. So we have right now uncommon. What do we mean by our second prong, that focus on danger? What is the sort of, it's uncommon for people to have pet llamas. Most people don't. But that's not an abnormally dangerous activity. We're not scared about pet llamas because of the absence of danger. So they do spit, which is gross. Or so I've been told. I did grow up in Oregon. So what about this danger aspect? What sorts of dangers would we be talking about with respect to AI that would make it fall into this abnormally dangerous activity category?
Right. So there's two broad sets of risks that I worry about There's misuse risks. So you could be building something that has what are called dual use capabilities. That if it fell into the wrong hands, someone could do something really bad with it. I think you could say it's plausibly abnormally dangerous to be doing that, at least without very strict cybersecurity protocols. And then the other is sort of misalignment risk. So we're building these machines that at least the people who are building them say they expect to eventually be broadly as capable, if not more capable than humans across a wide range of tasks. And there's this risk that they'll have goals that are not quite the ones we intended, or we didn't think carefully enough about those goals, and they optimize really hard for them. And that produces bad consequence for sort of humans who aren't part of the goal that they're trying to achieve. Right. So you can imagine, an AI system that's like trying to solve scientific problems. It wants to discover like new theories of physics. Right. And it wants to build a new, bigger than CERN particle collider. Right. And it needs lots of resources to do that. And, people's houses are in the way, people's bodies are in the way. It just doesn't really care. It's also worried that like maybe someone's going to try to shut it down. So maybe it has to take some preemptive action to try to prevent that. You can just imagine lots of people getting hurt along the way. Right. And so if you're building a system that has that kind of power, and you're not, confident you can control it, which again, the people who are building systems concede they're not, at least most of them concede they're not confident they can do that. That seems like a pretty dangerous thing to be doing.
So if we accept the sort of two premises here that they're uncommon and they're dangerous, well, in this instance, this is a means of getting at the activity level, right?
Mm-hmm.
So if you're going to say this is an abnormally dangerous activity to be developing frontier AI models, just like we're saying it's abnormally dangerous to blow stuff up with dynamite, well, the result of declaring that with respect to dynamite is most people don't carry around dynamite wisely and thankfully. But does that mean to kind of push you here from a innovation standpoint, if you're saying, or from a national security standpoint, hey, great, you may say under the law that this is an abnormally dangerous activity, but we can't diminish the level of exploration of the frontier, because if we don't, China's going to, and we can't lose that race. What's the response there?
Right. So first of all, I don't think it's true that just because you bear the cost of harms you cause or risks you generate means that you won't engage in an activity. Right. So if an activity is highly profitable, it can still be profitable even when you pay for the social cost. Right. So my background is in climate change law and policy, right? Electricity, gasoline to power cars are very socially useful, right? But they also produce pollution. And most economists will tell you, well, we should price those externalities from that pollution, from the climate change and the local air pollution they cause, even though they're still socially useful and will still engage in a significant amount of that activity, just not more than is socially optimal. Right. And so that's what I would say in the AI context, is that most of the risks that these systems are generating, these American systems, are risks to other Americans. And we're not sort of getting one over on China by not sort of compelling the people who are building these systems to take account for those risks. I also don't think it's true that China is totally ignoring these risks either. Right. And so there's this risk that we sort of, both sides use each other as an excuse to be incautious. And I think that would be a bad equilibrium. I think we should be trying, to the extent it's geopolitically feasible, to reach some accord with China, to both, engage in responsible development and mitigate risks that spill over across borders. But I don't think that in the absence of that, it makes sense to say, well, we should just let it rip because, we don't care about protecting our own people because China might not protect theirs.
And I was just thinking, we may need to have a "Let Her Rip" bumper sticker for AI with put that on some truck somewhere. But we'll leave the merch for another conversation. For now, thinking about the potential exposure to liability, of course, the potential exposure to liability almost always leads to a conversation about insurance. And one question you've studied and thought deeply about is this notion of, what would it mean for a lab to get insurance? To have insurance, you need some sort of quantifiable risk, right? The reason we have life insurance is that someone has full degree and mastery of actuary tables. They can look up, hey, you're 33 or whatever, you eat a lot, what have you, you're going to die when you're 75, statistically speaking. What does that even mean in the AI context about how we could begin to develop an insurance regime that's accounting for some of the risks we've discussed?
Right. So I think what you're getting at here is that the risks from AI are non-actuarial, right? We don't have a lot of data to draw on. And so, I'll be honest, I don't know what the answer is here. I think that's a technical question of like how insurance companies should do the underwriting for these risks. But I think when you think about that, that shouldn't make you think, well, we shouldn't require any precautions here. We shouldn't require that they demonstrate ability to pay for the harms they cause, either by taking out insurance or by setting aside enough, safe capital assets, right? I think that's, the fact that we can't measure these risks is a reason to proceed carefully, right? And so, yeah, I think the basic principle is we should say is that you should pay for the harm you cause. And when you're potentially producing catastrophic harm, there's some limit as to how big a risk is insurable, but up to that limit, you should be able to demonstrate that you have the ability to pay. And then we might want some other mechanism for mitigating uninsurable risks, which we can talk about if we have time.
So we've covered negligence, products liability, abnormally dangerous activities. Are there any other big heavy hitters you want to make sure our students, aka listeners, walk away with?
Right. So I quickly mentioned this idea of vicarious liability, right? So there's this doctrine that you probably learned about if you're a law student or a lawyer in 1L torts, called respondeat superior, that says that employees are responsible for the torts. Employers are responsible for the torts of their employees. They're committed within the scope of employment. So this is a version of vicarious liability. You can imagine a similar regime for AIs, where if an AI system does something that would be a tort if a human did it, then either its user or its developer or deployer, we could decide who we think is the principal for different purposes. It might be different for different kinds of failure modes. Then that person is liable for the torts of the AI, and that would be a form of strict liability for the humans, even though it would be a negligence or intentional tort theory for the AI. The other thing I just want to mention is there's this idea called punitive damages, right? So I was suggesting we might want some tool for getting at what I call uninsurable risks, right? So there's risks that are so large that either it's financially uninsurable, any damages award wouldn't be enforceable, it would bankrupt the company involved, or even larger than that, the legal system's no longer functioning, or in the limit, we're all dead and no one's around to sue or be sued. And so obviously you're not going to use ex post compensatory damages, the more normal type of damage we have in a tort suit in that type of scenario. And so one of my proposals is that we use what are called punitive damages. These are damages over and above what's needed to make the plaintiff whole for the injuries they suffered. That are designed to punish the underlying activity. And particularly, we use them in cases where, there's an injury that's small enough to be practically compensable that we can force a damage award, but it looks like it easily could have gone a lot worse and generated an uninsurable catastrophe. And so you should be held liable, I argue, not just for the harm you actually caused, but for the uninsurable risks you generated.
And thankfully, this is included in our extra credit reading. Your excellent take and fascinating take that even reached Vox, which is awesome to see law and AI scholarship getting popular attention. So, Professor Weil, it's been a great privilege to have you. Thank you for spending time with the Scaling Laws Academy. And for now, we're going to have to let you go.
Okay, thanks so much. Appreciate it, Kevin.